The FTC intends to protect gig workers from unfair, deceptive, and anti-competitive practices. That's the latest word, which means we're going to have more heated talk about how you define independent contractors. Here on this roundtable, we've got two gentlemen that can do that just as well. We have John Kingston, our editor-in-chief, writer at large, of freightwaves.com, and Matt Leffler, our armchair attorney out of Chicago, Illinois. Gentlemen, thank you so much for joining us. John, clearly there is some momentum behind what we're seeing here. Obviously, AB5 maybe have lit a fire about how you define independent contractors. The Biden administration is talking about changing the rule. The NLRB is looking at making a new rule. The FTC now chiming in saying they want to enforce the rule. Where are we headed in all this? I mean, is this an issue that's just gaining speed and we're headed towards some sort of a conclusion at some point, possibly early 2023?
Oh, there'll never be a conclusion on this, that's for sure. When I started covering independent contractor rules, and I started covering AB5, I kept waiting to find the rule, the definitive legal decision that established it, whether a person is an independent contractor or not. And I concluded pretty quickly that such a decision doesn't exist. There's a lot of conflicting case law on it. Now, in the example of the federal government, there is a change in administration from the Trump administration to the Biden administration. The Biden administration is very pro-union, likes to fancy itself as pro-worker, and the left of the country tends to favor the idea that workers are being exploited at their gig workers and they should be more readily classified as employees. So that's what you have seen so far. The only definitive thing that you can say has happened is that FTC statement of policy. It's not a new rule. What they're saying is that they're going to look at given the powers that they have, they're going to look at whether an employee is classified correctly, but that's not really their remit. So they have to kind of look at it through an antitrust perspective. So it'll be a different approach to the law that the FTC would take than you get out of the NLRB. Now, in the case of the NLRB, we had a Trump administration rule that was more favorable to the idea of a worker being an independent contractor. That went into effect literally 2 weeks before Joe Biden took office. The Biden administration yanked it, said they were going to do their own rule. A court said the yanking was legally incorrect. That was put back into place, and now we're waiting on the Biden administration rule, which we would expect is going to be more favorable to the idea of a worker being an employee rather than an independent contractor. And the sort of consensus in the freelance community that wants to stay freelance is that the ABC test will be in it. And the ABC test was not in the Obama administration's rule. So that's where we're at.
All right. That's a good summary of where we are here. Matt, looking forward here, it seems to me, as John just eloquently stated, that the simplest solution tends to be the right one if you're an Occam's razor fan, but in this position, it looks like the simplest solution is not going to be the one to go after. What do you see as how, especially as you apply the kind of independent contractor rule legally, is this going to be maybe a different rule for different industries, or do you see the federal government perhaps, again, making the simplest solution the right one they want to take?
That's a great question. Now, about a decade ago, I had a chance to interview for an in-house position with a gig company. And they said, look, no one knows how to regulate us. We're a brand new entity. No one understands it. And I said, we've been doing independent contractors for 40 years in transportation. This is not a new type of law. And so what the data we see from these gig companies is astonishing. Over 16% of Americans are earning some form of money through the gig work. And some of the surveys have shown that about 14% of gig company workers are making underneath the minimum wage. So there is a massive need for some sort of regulatory framework. So the FTC has been stepping in and saying, well, what do we do really well? We do some good stuff on competition law and consumer protection. And maybe some of the ways we're going to approach this is looking at what do the gig companies say you're going to do? What are the revenue you're actually going to make? What are the earnings reasonable? Are we going to look at the way that you have your cost structure put together? But if we're looking at the ABC test, if that gets deployed at a bigger scale, it's going to be really interesting because these entire gig companies depend upon cheap labor. They are condition precedent of not having to pay health insurance or unemployment insurance or workers' compensation insurance. So all of these little things that we find as cost savings on the gig gig company platform is something that they're not going to be able to absorb. And so likely we're going to have a whole lot more challenges of what it is to be a worker. And these rules, when it comes to who is an employee and who is a contractor, it's a test. It's fact intensive. It's very specific to the given case. So we use these tests like the ABC test to understand who controls the person. What is the hiring entity's responsibility in what they do? And does that person doing the work, are they actually an independent business, or are they just doing one thing for one person at a price that is below market value?
Yeah, John.
Yeah,
Go ahead,
yeah,
John.
let me just jump in here. And Matthew, tell me if I'm wrong here, but the rule that the Biden administration would propose under the NLRB would be administered by the Wage and Hour Division. So it's their definition. It's not a law. So I remember speaking to an attorney once saying, "Well, can't you just ignore it? I mean, it's not really a law." And his response was, "Look, you always run the risk then of coming up to an action by the NLRB. Any good lawyer would tell you to keep yourself safe. So really, in some ways, would you see the ABC test as becoming almost like a law that everybody wants to comply with the rules of the NLRB, lest they get hauled up in front of them, even though only a small percentage of companies would have an action brought against them by the NLRB?"
Yeah, Matt, you wanted to
That's a great question. Yeah, absolutely. That's a really good question. So administrative agencies have executive authority. They're not statutes necessarily, but they're empowered by these things. The ABC test, again, is the most common test we have in the business of employee classification. Over 20 states use it. So if we have a rule put in place, it might become the de facto standard we all go to. And I think that that's probably a likely outcome, is what is the most rigorous test that we see adopted across the country, and how do we make sure that as an employer, a hiring entity, we are protecting ourselves? Because that type of litigation, that type of liability, it's not insurable. This is stuff you're paying for out of pocket if you get processed against this. So you want to be as far compliant as possible. And again, back to the data, 30% of people in a recent survey about gig workers were using SNAP benefits. So we are, as a country, we are paying for these people to have the jobs that they have some way or another. And it just seems to be, in some cases, it's the gig company might be in the best position to compensate their workers in a way that's going to alleviate some of the stresses they have on food insecurity and financial insecurity.
John, let's go back to the point that you made a little bit earlier, if I may. What's the difference here? Say, for instance, obviously we're talking about changing a rule, not necessarily a law. Why wouldn't the Biden administration, at least at this point in time, given the current political outlay of Congress and the executive branch, try to do something and try to codify an ABC test or a law that would overrun a rule per se?
I'm not sure that answer, and I don't really know that there is a federal law now. I mean, as opposed to, you mentioned the word codify, there is a series of decisions by regulatory agencies, and there are rules at regulatory agencies, and then there are state rules. So there is not really a federal rule on this.
Right.
And that's kind of the issue here, because let's point out that we are a little more than 2 years away from the next presidential election day. And if the White House were to change hands 2 years from now, all the work that the Biden administration staff members and attorneys are going to put into devising a new law under the NLRB could get tossed out by the next administration as quickly as the Biden administration tossed out the Trump rule, though that eventually was ruled that they couldn't do that. So, the main thing is here is, and this is not a knock on lawyers, but they're all going to get rich here. And that's because the rules keep changing over and over again. I mean, you think you could bring your company up to speed with the rules, and then you get a new administration and all the rules change and you got to do it again. So, I mean, this is like the Legal Profession Full Employment Act.
Let me just push back on that just a little bit.
Very quickly, Matt, very quickly.
Yeah, so the thing to keep in mind here is that what the FTC is likely to do is put out a promotive rule in probably Q1 of next year. So that rule will be put out. People will make comments. They'll make changes. We're probably a long ways away from seeing a real big change in how this works. I will just mention at the very end, the franchise rule and the business opportunity rule are two things the FTC is looking at, which it comes to how do you communicate about what it is you're going to do as a driver, what is it going to be as your cost structure, and making sure that those levels of communication are accurate as opposed opposed to potentially, not exactly what the reality looks like for those drivers.
Matt, we got about a minute left here. Let me throw the last one to you here. How much of this is simply not going to work? In other words, we've seen AB5 go into effect in California, and then immediately we've seen changes in structures that would allow employees to work as independent contractors under another company name. How much of this do you think is just going to be a shifting sands situation where the independent contractor is just going to find another way to live as an independent contractor?
I think the great example is what multi-homing is. So if you're a gig company worker, you might be working for multiple gig companies. And because you're doing multiple gig companies, you're pretty much independent. Maybe you'll see a path where people are encouraged or required to make corporations, either sub-S corporation or a limited liability company. There's ways that we'll still get the same effect, I believe, but we're going to probably see higher cost in these platforms because of the compliance aspect that they're likely going to have to absorb as time goes on. But I think that it's going to keep changing. Wait a few minutes and it'll be a new outcome. So we just got to keep paying attention to what people are talking about and what the data shows us.
And waited another couple of years and we could see something different from a different administration. It clearly is a debate that is going to take longer than 11 minutes to solve. We will take a break here. Thanks so much for joining us. And we will come back after this with more for Waves Now.